Okay. Again, welcome everybody. Hope everybody's having a good morning so far. And we have with us today, there's no stranger. We have Elizabeth Brackett with us today. Uh, Elizabeth is an independent local HR consultant. She's got over 25 years of experience in this fun stuff. So we're going to get to talk to her today about a very interesting topic. No matter what your opinions are of the Supreme Court and any decisions that have come down, our responsibility to you is to make sure you know what's going on and to make sure you don't get sued. You know, we do live in a sue-happy environment these days, and we just want to make sure you're educated in what the law is and what the expectations of that are. So without me rambling on, I'm going to go ahead and introduce Elizabeth Brackett. And Elizabeth, if you can, the webinar is yours. So go ahead and introduce yourself. One quick thing is we will allow some questions. So if you have any questions on anything she says, you can send a quick text within the system, and then we can definitely ask those questions. So Elizabeth, it's all yours.
Okay, great. Well, thanks for having me, everybody. Good morning. As Marty said, I have been doing this a long time. I am one of the people that thinks this is interesting and intriguing, and but I am glad that God made people like Marty, because I don't enjoy benefits. So between the two of us, we make a great team. So the conversation that we're going to have today is about respect in the workplace and anti-harassment. I have, as Marty said, been doing this since about 1995. So people can do the math and figure that out on their own. I've been in the game a long time. Harassment is something that needs to be a conversation in everybody's workplace, but there is a right way to do it. And so that is really what my intention is to talk about today, is how can employers do the right thing as far as harassment is concerned. Interestingly, when I started in HR, the conversation around harassment was more what we call pinch a pretty secretary type of harassment. And on the bright side, on a positive note, that's not really the conversation we're having anymore. But when it comes to harassment now, it is a lot more of a nuanced conversation and a lot trickier. But an employer has the opportunity to get it right. And by getting it right, they can reduce the risk greatly for everyone involved. So the session objectives today we'll go over in just a second, but what I'd like to talk about initially is what are some consequences of harassment claims in your workplace? And I'd like to open that question up to the group, if I can see the group. Let's see, here we go. So I'm not seeing any responses, so I'll go ahead and talk through it. But Marty, if you get any responses to that question as far as consequences of harassment claim, chime in, okay?
Okay. All right. And the ones that's on, I'm going to allow you to be able to talk. So if you want to be able to mute your computer, I'm going to allow you, if you've got a question, just to ask it and just let us know who you are. And that way, Elizabeth will be able to answer any kind of questions you have. So that ability is there. So just unmute yourself when you want to ask a question, and you'll be able to do so.
Okay. So consequences of a harassment claim. So for those of us that have been through this, which sadly I have, you know, I think that we tend to think about the consequences. Some of the obvious ones are for the employer itself. So right out of the gate, we talk about money. So having a harassment claim is going to cost you. Whether or not you hire somebody like me to do a neutral, independent, third-party investigation to an allegation that you had. If you do it internally, then you've got manpower dedicated to the investigation. But what else? We've got things like turnover. So anybody that's been through this knows that a harassment allegation is a little bit like a mushroom cloud. So you start out with this tiny little complaint, and very quickly it grows into this gigantic mushroom cloud that wreaks havoc on your workplace. So, right out of the gate, we've got money for the employer, we've got turnover, we've got productivity issues. Again, this mushroom cloud, guess what that means? That means nobody is working. Everybody is sitting around the proverbial water cooler talking about why is Mike in Elizabeth's office? Did you see Sally in the bathroom yesterday? She was crying. Why isn't Susie at work today? That is what is going on instead of actually getting the work of the business done. So there's huge productivity issues. So you've got the workers distracted, you've got the employer spending money and not getting work done, you've got perhaps the reputation of the business on the line, the morale of the individuals in the workplace. But who else is involved? Well, there's the victim or the alleged victim. So certainly he or she has emotional restraints right now. She or he has productivity issues. They may be absent, suspended, calling in sick, wants to work on a different shift. So there's a lot of issues for the person that has put the allegation forth. And then also you've got the alleged harasser. I mean, this is their career too. So there are impacts to that person's career, potentially productivity issues. Certainly we've had situations where there are misplaced allegations or misunderstood situations. All of those things are important consequences for the employer. But if the employer is doing a good job of talking and communicating and writing policies, they're certainly in a better situation to deal with these and hopefully reduce all these consequences. So what we're going to talk about today is a recent Supreme Court decision and the impact that it's going to have on your workplace and policy. Going to go through the definition and talk about how we recognize harassment. Look at the importance of training and educating your employees. What is a good harassment policy? And looking at what your responsibilities are as an employer. So what the company's commitment should be. One important thing that I need to explain is that you need to have a multiple avenue for your employees to complain to somebody. If your harassment policy says talk to your supervisor, talk to your manager, period, then that is a problem, because the EEOC guidance, and they're the governing body that will look into this. In South Carolina, you have the Human Affairs Commission that partners with the EEOC, but those agencies will look at, did the employee have the opportunity to complain? And if your policy says talk to your supervisor and a person isn't comfortable talking to their supervisor, or a person feels that the supervisor is responsible for the harassment and they don't have another avenue to complain to, then that policy does not meet the standards and therefore does not help you reduce the risk in your organization. Your policy needs to be clear that they can talk to their supervisor, and then give them a couple options. Now, a lot of times I will see a corporate policy that says, talk to anybody. And I discourage companies from having that loose of a policy, because if your policy says, talk to anybody in a leadership position, you better be sure everybody in a leadership position is trained to know exactly what to do if somebody talks to them. So my advice is to tell them to talk to their HR, the HR practitioner, their manager, their supervisor, and give them another alternative. So pick a few people in the organization that you feel confident and comfortable with that can handle a report of an allegation of harassment, and rather than simply leaving it broad, that they can talk to anybody in a management position. So that's my advice. When it comes to harassment, the other thing that you need to understand is harassment is not how it is intended. It is how it is perceived. So just because somebody didn't mean anything by it does not mean that it is not harassment to the person that either overheard it, heard it, it was directed towards. So when it comes to harassment, it is absolutely how it is perceived. So if we start with a culture of respect in the workplace, then ideally we do not have unintended conversations or jokes or cartoons or whatever about inappropriate things that will upset somebody. So please be aware that, you know, when I go into a company and do their training, I don't spend the entire hour talking about harassment. I spend a lot of time talking about respect and treating their co-workers and colleagues and partners with respect, rather than spending the whole time talking about harassment. The other thing that I want to be sure that we talk about as far as what the company's commitment is harassment includes off-site and non-employee behaviors. So just because it didn't happen at work doesn't mean it's not the employer's responsibility. So if you have an allegation or a rumor brought to you, then it happened, you know, at the bar during happy hour on Friday night, and you think, well, that's not my problem. That is not right. So if you have employees off-site acting inappropriately and someone gets upset about it, and like I said, you either hear about it or somebody brings an allegation to you, your responsibility is that you have to look into it. You have to investigate that. And then includes applicants, vendors, clients. So things like that. If you have an employee that complains about something that is happening either off-site among coworkers or with people that they come in contact with as part of their business responsibilities, it is also your responsibility to look into that and to do an investigation. So when we talk about the definition of harassment, harassment is unwelcome conduct that is based on a protected category. So again, it is unwelcome behavior. This is not two employees dating. It is deliberate or repeated. It interferes with your work. So that is the most important thing that I can stress as far as how do we define harassment is if it is interfering with your work and creating that intimidating, hostile, or abusive, offensive work environment. Harassment is very hard to define. You know, you cannot have a list in your handbook that spells out exactly what harassment is and isn't. The EEOC has some definitions about what is and isn't, but except in very extreme cases, we have a hard time saying what is and isn't harassment. Harassment is in the eye of the beholder. What one person thinks is funny, another person can be offended by. And I can't tell you how many companies I work with and appreciate and love this about them. They say we are one big happy family. But the problem is that you are one big happy family until you are not. And that is where we're trying to protect you and to mitigate the risk by doing training in your workplace and having a good policy about it. So things like jokes, cartoons, teasing. I was just teasing her. Those are the things that will absolutely get you into hot water. And while I appreciate that we are all one big happy family, it is not always okay. You have to also look at the culture, both of the organization, but also of the individuals. We live in a diverse world these days. So what is okay to me based on how I was raised is not okay to the next person. I don't think twice about somebody coming in for, well, I do now because of COVID, but pre-COVID, I did not think twice about somebody coming in for a hug, a coworker, a colleague, somebody that I haven't seen in a while. That was absolutely part of how I was raised and part of my culture. But not everybody's okay with that. When we talk about harassment, we have to look at the fact that there are levels. So there are levels of harassment, things like just inappropriate. So I would consider inappropriate level something like a cartoon or a racy calendar that somebody has up on their desk, a dirty joke that's getting circulated, things like that. But then the escalation is up to the point of true harassment and ultimately violence. So that is, when we see things that are truly harassment and violence, those are the ones that we recognize without a doubt. I had years ago a friend of a friend who had to do her quarterly sales conversations with the owner of the company, and the women had to come and sit in his lap to go over their sales numbers for the quarter. And obviously the men didn't. So when we talk about a story like that, no doubt about it, right? We got it. But when you talk about somebody, circulating a joke or standing in the break room showing a cartoon or something like that, that's where it gets a little bit gray. What the EEOC guidance says is use the reasonable person test. Would a reasonable person be offended? Now, again, think outside your big happy family where we all tell jokes and it's all okay. Think about outside the big family and try and decide, would it be okay to a reasonable person? And when I teach this class in workplaces, I tell people to use their grandmother test or use the newspaper test. If your joke, comment, conversation, calendar, fill in the blank, if that showed up in the newspaper with your picture attached to it that you said it, or would you say it in your grandma's living room? So if those two things make you go, I don't know if I should say that, that's what I consider the reasonable person test. So be aware that that is what the EEOC looks at when they get a claim and they try and decide, is this, was this okay? They don't necessarily look at, was it intentional? They look at it, was it deliberate? Was it repeated? Did the person have their work interfered with? In some way, was the person intimidated, hostile, offended? And all that's going to go back to that reasonable person test. Could you say it to your grandma? The other thing that I like to talk about when I teach the classes is, let's talk about what it is not. Guess what? Performance feedback is not harassment. If the expectation is that you're supposed to be at your desk or your work center, or your shift starts at 8 o'clock and you are consistently late, and I, as the employer, reprimand you, put you on a performance improvement plan, give you feedback that you are not meeting the standards of me as the employer, a lot of times employees will get in their head that they are being harassed, and that is not harassment. Assuming you aren't doing it to somebody based on their individual protected circumstances and that you're treating everybody the same, that is not harassment. So I have had so many employees come in my door and explain to me that they Googled hostile work environment, and their boss is absolutely creating a hostile work environment because he or she is writing them to be at work on time or to get their numbers up, etc. That is not harassment. That is performance management. And so I have to share with the employee that that's not a hostile work environment. That is simply us trying to manage your performance. So when we talk about the company policy, these are the protected categories that are recommended that you have in your handbook policy. This should be on your website. This should be in your handbook. It should be on the bottom of your application as far as your EEO policy. So race, color, sex, religion, national origin, age, disability, pregnancy, or genetics. Now, you may have in the city that you do business in or the state that you do business in, you may have some additional categories. But as far as the federal categories, these are what are included in the federal protected categories. So briefly, let me talk about genetics. This is one that was added several years ago, but as I do handbook reviews for my clients, a lot of them have not added genetics to their policy. So there's the Genetic Information Non-Discrimination Act, otherwise known as GINA, and we in the HR field sort of jokingly laugh that GINA is a law looking for a problem, because in the 20 some odd years that I've been practicing HR, I have never had an employee come to me and say, I think I was discriminated against based on my genetics. And I have never had an employer come to me and say, I have this information about genetics for my employee, and I don't want them to work for me anymore because of their genetics. The reality is it does not have a lot of traction as far as claims, charges, but doesn't mean you don't need it in your handbook. So be sure that you put it in your handbook, and be sure that you speak to it when you do employee and supervisor training in your organization. The interesting one that we need to talk about is the word sex. So the Bostick versus Clayton County, Georgia Supreme Court decision that came out earlier this year is, for those of us that are HR nerds, and I'm pointing to myself, this is a very interesting one. So Title VII, 1964, Title VII, it did not say anything about gender identity, sexual orientation, transgender. That wasn't even on their radar. So when you look at Title VII, whether or not sexual orientation, LGBTQ is included in that, it wasn't. And so for many, 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 many years, up until very recently, the question of, is sexual orientation a protected category? The answer was no. So things that fell into sexual orientation, LGBTQ, were not a protected category. Now, I certainly was advising my clients to do the right thing and the fair thing, but if they went back to Title VII and the federal law, was it on the list? It was not on the list. So a few years ago, the EEOC again, the governing body that investigates these for employees, they took the stance that sex was a broad term. And so it did not just include gender. Their stance was, well, if somebody is let's use gay as an example, and you fire them because she is a woman and she dates women, ultimately that goes back to the fact that she is a woman. You wouldn't fire a man for dating a woman, so you are ultimately using a person's gender to make a decision about an employment matter based on the person's gender. And so the EEOC, again, took a very broad view of what the word sex is and said, no, as a matter of enforcement, if we find an employer that is using somebody's sexual orientation, gender identity, if we find an employer that is using that as a decider in employment matters, we will go ahead with the investigation and the charge and proceed as if it is a protected category, even though Title VII didn't reflect it. So now what we have is the Supreme Court has caught up. So basically the Bostick decision comes down to the employers need to be sure that as they look at their policy and look at the word sex, they look at it inclusively of LGBTQ. So I don't recommend that you change your policy. I certainly have seen policies from our clients where it says, which now includes sexual orientation or transgender. I don't know that that's necessary. I think that as long as an employer understands that the word sex has a very broad meaning now versus a very narrow meaning over the years. Any questions about that before I move on?
If you have any questions, don't forget to unmute yourself.
Okay.
Feel free to ask any questions.
So the other thing that I want people to look at in their policy is be sure that your policy does not guarantee confidentiality. You can't possibly guarantee confidentiality when it comes to a harassment investigation. Your policy needs to say, we will do the best we can. To the extent practical, we will protect we will ensure confidentiality to the extent practical within reason, but we still have to be able to conduct the investigation. So if your policy says something about promising confidentiality, I think that that needs to be addressed as well. The other thing that your policy needs to be clear about is the no retaliation statement. So in bold letters, underlined in your policy, it needs to speak to retaliation and the fact that it will not be tolerated in your organization. So that's best practices for your policy. When it comes to best practices to avoid a harassment claim, there have been a lot of cases that established these best practices. So obviously prevention is the best tool to avoid harassment in the workplace. How do we get to prevention? Well, anti-harassment training for employees and managers. So consistently, the courts have looked at, does an employer provide training to the employees and to the managers? So when I typically go into an organization, I have two different trainings that I do. Obviously, the employees training is different from what the manager's training is because the managers have an additional level of responsibility. So they have to be extra careful. If you as an employer are doing anti-harassment training, and we recommend kind of the best practice is about 12 to 18 months is best practice as far as how often do you do the training. So 12 months is ideal. Within 18 months is critical. So having harassment training for the employees and managers. And again, when I do the training, I talk a lot about respect for my coworkers, how to speak to my coworkers respectfully. So doing that training for your employees and for your managers is a critical step to reducing the risk in your workplace. You have them sign off that they attended the training. You hand out the harassment policy in the training. You have something for new people coming in that they go through, a mini version of it at onboarding, especially management, if you're hiring a new manager. So having that harassment training and proof that they attended it. The other thing is the harassment policy. You want to distribute your harassment policy once a year and have employees sign off on it that they've seen it. You also want to have it posted in your break room or on your intranet site on your homepage where your employees, if they have a landing page that they go to, have your harassment policy there. Distributing your harassment policy once when they get the employee handbook is not enough. Again, you want the EEOC to be able to look at the commitment that the employer has to avoiding this. And then, I hate to say it, but then if you do have a charge or a claim, the thing that's going to help you is to be able to say, we did everything we thought we should. We did everything we could. I had a client years ago who had the EEOC was coming in and they were doing a discrimination investigation, and the EEOC is walking around the workplace and they walk up to a random guy at his cubicle and say to him, "Do you know what the harassment policy is?" And the guy says, "I mean, don't do it, but hang on. It's right here in my desk drawer. It's right here on my intranet page. And I go to training once a year to learn about it, etc." And when the EEOC gave them their decision process back, that was one of the things that they said was, this employee had within his fingertips the harassment policy. He knew where it was. He had his handbook in his desk drawer. He knew where that was, and he knew he'd been in training for it. He could show him in the break room where the harassment policy was. So while he couldn't recite it, he knew the gist of it, and he could present it at his fingertips. So that employer demonstrated to the EEOC that they were doing their best. As far as an effective complaint and grievance process, so you want to be sure that you have multiple avenues for them to complain. You want to be sure that you have an environment where people are okay to talk to somebody. Again, that is sometimes a good HR person. It is sometimes their supervisor. It's a good manager. It may be an ethics hotline of some sort, but they have an avenue, and you have something that lets people feel comfortable. Your culture is something that lets people feel comfortable to talk about it.
Elizabeth, we do have a question here. The question is this acceptable verbiage? And this may be one that maybe they can reach out to you a little bit later, but to grasp the whole thing. But it says in our harassment policy, we have the following that reads below. It says, "We will investigate the report and then take prompt, appropriate, or remedial action. The company will protect the confidentiality of employees reporting suspected violations to the extent possible, consistent with our investigation. You will not be penalized or retaliated against for reporting improper conduct, harassment, discrimination, retaliation, or other actions that you believe may violate this policy."
That sounds good. I want to be sure that she's got the retaliation piece in bold. And then what you didn't talk about or what you didn't read me is something about, these are the protected categories that, the company does not discriminate and will investigate harassment based on race, color, religion, age, disability, national. I wanted to say that too. Now, she may not have included that in her Q&A. I'm assuming it's in her policy, but what you read to me is good.
Okay, good deal.
Okay. So again, I've had a lot of employers say to me, well, what if they never complained? So somebody has something going on at work, and they either, this is a common scenario, they either go to the EEOC without telling anybody, go to an attorney without telling anybody, or they quit because they can't take it anymore, and then they go to the EEOC or to an attorney. So the question is how do I, as an employer, meet my standards of responsibility if I never knew about it? So a couple of things in answer to that pretty common question and pretty common scenario is, one, if you truly didn't know about it, then you couldn't be expected to act on it in terms of investigate. But if you should have known about it, if you could have known about it, you know, if it was a rumor, if when you get this EEOC charge, you call the supervisor in your office and the supervisor says, well, yeah, Sally told me about that, but honestly, we thought she was just blowing smoke. Or, you know, we heard about that night, but I think everybody was pretty drunk, and so everybody was misbehaving. Things like that. You know, if your supervisors know about it, then guess what? The employer knows about it. So supervisor equals employer. So you need to be sure that your supervisors are educated through training to know when to raise the red flag. Even if they don't know what to do, they better know to call HR or call their boss. They need to know to call somebody. So if you should have known about it, you are on the hook for it. And again, this goes back to having a good policy and good training in the workplace. If somebody goes to the EEOC and makes a claim, and you present to the EEOC, hey, we didn't know about it. She never came to HR. Our policy is clearly communicated. We send it out once a year. We have an HR person conduct training once a year. You know, our policy says you must report harassment if you are impacted, see it, overhear it, etc. We have this policy in place, and this person didn't take advantage of the policy that is clearly communicated and employees are trained on it, then the employer can say, we had no idea this was going on, and had we known, we would have acted on it. Again, it comes down to the employer having credibility with the EEOC that they indeed would have done something about it. So what are the employer's responsibilities? You have to take all the questions, concerns, and complaints seriously and respond appropriately and promptly. Let's talk about promptly. Promptly does not mean weeks later. I appreciate the fact that HR people are busy. I appreciate the fact that CEOs or presidents or leaders of the business division are busy. But again, the last thing you want to do is to have to explain to the EEOC why it took you 3 weeks to respond to this allegation. You know, to put it quite frankly, you need to get the show on the road. It is absolutely critical that you move quickly, and you still have to move appropriately. So you can't rush into it and do things wrong, but you have to have visible reactions that show that you are trying to move forward. A lot of times, the complaint that we get as HR people or even supervisors or managers is they want to tell us something, but they tell us not to do anything with it. I want to tell you something, but I don't want you to tell anyone else. I don't want you to do anything. You cannot promise that. You cannot act that according to that request. And so employees need to understand that we want them to tell us stuff, but we're obligated to react to that whether it be go to HR or investigate or go to the manager, etc. So, just because somebody says this is off the record or please don't do anything about this, unfortunately, we are obligated to act. The other thing I'll mention is it does not have to be an official complaint. I have absolutely had employers say to me, well, we told her to put it in writing and we never heard from her again. So that doesn't count either. It is an official complaint regardless of how you receive it. It doesn't have to be in writing. They don't have to use your official ethics hotline or the 1-800 number or whatever. So please do not delay in acting, and please remember that everything counts. I had a client and the employee in HR was promoted out of the line of business into HR and was an HR admin. And so her friends that were in the business unit would still come and chat her up. And one of the things that they were chatting her up about is, the manager that acted inappropriately at the sales conference last month. And the employee ended up getting fired, unrelated to all of this, but the employee got fired, and the first thing she did was go to the EEOC and make a claim of sexual harassment. And in her claim, she said, I told HR. And HR is standing around going, did anybody ever talk to her about this? And the answer was yes. The HR admin, and they were friends. They had joked about it and laughed about it, and she had seen the text messages from the creepy guy at the sales conference. But she didn't think it was a complaint. It was just everybody laughing about how badly, Bubba acted at the sales conference. But when she went to the EEOC after she'd been fired, she said, I believe I was fired because I complained and HR never did anything. So guess what? You can just go ahead and think commas and zeros on the check for that employee because HR didn't do anything. Okay? As far as the appropriately documenting every complaint, document. But please stick to the facts. I want you to, again, think about the newspaper test. If your document or this page was published in the newspaper, would you be okay with it? I will help clients all the time try and draft the appropriate documentation, whether it be for an unemployment claim or an EEOC charge or a internal sexual harassment investigation. And, a lot of times, especially a manager has a lot of emotion involved in this. They are sputtering mad that they are having to do this. They assure me that they did nothing wrong. And so that comes across in the language. So if you are writing this document to preserve the data from the investigation, the notes from the investigation, the final summary of the investigation, please, please, please think about how you write it. All of that information is discoverable. So if this goes anywhere further, God willing it doesn't, but if it goes anywhere further, you do not want them uncovering, documents, emails, pages of notes that say things that are not factual, that are completely based in the opinions. I had an employer one time who was responding to an unemployment claim, and his response was, she was a crackhead. And my conversation back to him was, no, the answer is she violated your drug and alcohol policy and failed the drug test. So you want to think about how you say something in terms of, if a stranger was reading this, what would they get from it? Would they get that you're mad? Would they get that you run the kind of business where you call employees names? No. You want to be sure that you are giving them a document that is cleaned up, speaks to the credibility of the workplace, and does a good job of enhancing the person's opinion of what kind of show you're running versus something that speaks to anger or frustration, things like that. The investigate. So the employer needs to investigate promptly. There may be some value in having a third party come in and investigate. The EEOC certainly looks at that as one of the factors that they consider. They'll look at how prompt and who did the investigation. So again, if a third party is coming in to do the investigation to look at a harassment claim or a discrimination claim, that's one of the things that they will consider is, was there a neutral party, whether it be an HR person or whether it be an external person looking at this. The disciplinary action that you take is also a critical piece that the EEOC will look at. I had an employer years ago who they had an employee who they went to a sales conference and the employee acted incredibly inappropriately, negligent, to the point that the women had literally moved furniture in front of their hotel room doors because they were so uncomfortable with this person and the way he was acting. I'm not going to get into the gory details, but just imagine, hotel room, Miami, sales conference, drunk, and his behavior was astoundingly bad. And so the employee, the next morning, rather than getting on an airplane with him and flying home, she rented a car in Miami and drove home. That's how upset she was. She got home, she told the leadership team what had happened, and the leadership team promptly called me to say, what should I do? And I said, the employee needs to be fired. And they said, but he's our best sales manager. Again, you are setting the bar for what is okay in your company for the EEOC to look at in terms of the level of discrimination or harassment, what the behavior was, and what disciplinary action you took. So if the EEOC were to come into that organization and discover those investigation notes, subpoena the employee, etc., you have set the standard in your organization as to what level of inappropriate behavior is okay. So be sure that your disciplinary action that you are taking matches what the employee, what your investigation shows happened between the employees.
Elizabeth, I'm gonna let you take a quick break and get you something to drink. I know how that is, but I'm gonna make a quick statement. This is why we have these, and we try to have something once a month to educate. Because I'm gonna give you a quote. I heard a cop say one time when got pulled over, and the statement was, "Ignorance of the law is not an excuse," and that's always something to keep in mind. To always educate ourselves, especially because I give you all credit, on the HR side. Y'all deal with a lot of stuff better than I could ever do. It's above my pay grade. But these types of webinars are here to educate, to help you along. Because, you sitting here thinking, I didn't think about that. I never thought about that. And it could be that particular thought that helps the company and helps you on down the line. So I just want to throw that in there real quick.
Yeah, thank you. And so the last thing that I want to say is you need to ensure there's no retaliation. So again, have the big statement in your handbook. But the biggest thing you can do about no retaliation is follow up with the employee. Have documented regular follow-up with the employee to make sure that he or she is okay. That is the best way to prove that you were making sure that the employee continued to be okay following this. So not just the handbook policy, but be sure that you've got it communicated, and then you've got documented communication.
Okay.
Any questions for me?
All right. You can send a quick Q&A text here, or you can unmute your mic if you got a quick question. No question is a dumb question. Okay. All right.
Again, having a handbook policy, a good one, having your handbook reviewed to make sure that it's in compliance and updated, doing this training, not this particular one today, but certainly a version of this, educating your employees, educating them, handing out your harassment policy, making sure your managers know when they need to raise a red flag, and your senior leadership knows how to act. All of these are critical.
All righty. Well, good deal. Well, Elizabeth, thank you. If anybody has a quick question, throw that out there real quick. Like I mentioned earlier, Elizabeth is an independent local consultant, and her website is brackethr.com, and that's bracket with 2 T's, brackethr.com. So make sure you reach out to her if she can assist your business in any kind of way. I don't see any other questions. Again, thank you. Hope you found this beneficial today, and I look forward one in another month or so as we find another topic that we think will be beneficial. If you have any topics, feel free to email me and say, hey, I'd like to hear something on this particular topic, and we'll be happy to do that for you. So, Elizabeth, thank you for your time, and thank you, everybody, for attending today.
Hang on, is there a question?
Actually, one did. Well, this person said thank you.
Thank you.
So you are quite welcome. And like I said, have a good day, and we'll see you soon.
Thank you.